Welcome. This is Pete Calabrese. I'm CEO of Can-Am Investor Services. Can-Am Investor Services is the FINRA registered broker-dealer affiliate of Can-Am Enterprises. We are one of the largest and certainly most successful regional centers in the history of the EB-5 program. I have the great pleasure today of being joined by Mr. John Pratt, partner at KKTP Law. He's the P in that KKTP. John is one of the, I would say, foremost, if not the foremost, authority on litigation in the EB-5 space. He and his partners have litigated successfully on so many different aspects that we're going to be talking about today, and how litigation can be used in the EB-5 program and when that time frame would be appropriate. John, thank you so much for joining us. How are you?
Great, thank you. Thank you for the invitation, Peter, and love to be here and share, some of the developments that are happening in EB-5. Obviously, there's some changes, there's some challenges, but there's a lot of successes and pitfalls to avoid. And obviously, like you said, litigation is part of the tools in the shed or your belt in order to determine and to try to maximize success, right, in the EB-5. EB-5 is a regulated industry, and as a regulated industry, sometimes litigation, both at the federal courts and otherwise, is necessary and required in order to, fix problems, overturn wrong decisions, and obviously keep the agency in check to make sure that they're following the law, they're following the letter of the law and the regulations and the statute, and they're complying, just like it's demanded that we comply. And again, I'm a partner at Cursman, Titzelli & Pratt in Coral Gables, Florida, Miami, and love to be here.
Well, thank you so much. And yeah, litigation is about as American of the overall system of law and order that comes into place, right? And it is a check and balance that needs to be done. But there is also, understandably, there can be some anxiety with having to litigate against the government, to have to litigate against anyone. It's not a comfortable feeling to be had. So as much as it's necessary and it's great to be able to do it, I think, and what maybe I'd just like to talk about for a couple of minutes here before we really get going is one of the best uses of litigation is to not have to litigate at all, right? So, in planning and in going forward in the EB-5 project, to be making this immigration-linked business investment, a lot of times what we talk about with people is that hopefully when done right, you get your full immigration, you get your repayment of funds, and litigation wouldn't be necessary. I mean, that's what Can-Am looks for, and that's what we try to provide as an offering to our clients. But I think it's always good to go through maybe what some of the good checkpoints would be when you're doing your initial planning for an EB-5, so that we don't have to call you, a few years down the line and hopefully have to get a little bit more detailed with the U.S. government on these sorts of things. So when you first start off in an EB-5 investment, it's really this great marriage between the immigration attorney and the regional center in putting forward the petition for an investor. Maybe just talk for a couple minutes about some of that prior planning that you would do, that you would recommend to a client on the outset of investment, so that you can do your best to avoid having to litigate down the line.
Right. I think you put it perfectly, Peter, in the sense that having a proper plan and a proper petition is it's both offensive in the sense that you are preventing possible problems down the road. Litigation is a tool, and it's a defensive tool if something goes wrong or there are delays or whatever the case may be. But you want to avoid it. You want and the one thing and you want to prepare for it if it's necessary. So avoiding it may mean you get your approval. There's no litigation that is required or necessary, whether you get an approval and you get it timely. But also, if there is an issue, you need to make sure that the record is strong enough to support litigation, because a lot of times when the record is deficient, that decreases the chances for further down protections like litigation. So, again, and I think you explained it very carefully, it's a marriage between the immigration attorney and representing the client and the regional center or the EB5 project. And what I mean by that is, as an attorney, I work with the client and I have to worry about what I control: source of funds. Where are they coming from? How did they move? Understanding the different cases that have explained the contours of that, understanding the regulatory framework, understanding the statutory framework, understanding the trends and the policy manual of what type of evidence is required to have a good source of funds, evidence and petition. At the same time, you got to look at the evidence that I'm getting from the project and from the regional center. Is it strong enough to prove how they're going to use the money? Where is it going to be used? Is the jobs are going to be created? So is that this two? I can prove where my money's coming from. I can prove it's legitimate. If there are challenges, I can survive it. If there's requests for evidence noise, I can survive it. I have the evidence. And at the same token, then obviously working with that regional center, that project, to determine, obviously, that yes, I can prove all these things too. How are they going to use the money? Where's the project? How are the jobs going to be created? And all these two things that need to be merged in order for a successful petition. And the third point, obviously, as an attorney, is how safe is my investment? And that deals with reputation, the trajectory of the regional center, and how established it is, the project of the regional center, et cetera, to minimize risk. Because a lot of my clients were like, look, I don't want to lose my money. I want to get my green card. I don't want to lose my money. And obviously having these different considerations goes into it a long way. And again, working with a reputable regional center with a proven track record is critical, because like anything in life, reputation matters a lot. That's why there's some better universities than others, or whatever the case may be. In the sense that if you look at the track record of successful, the absence of negatives, the return of capital, and then you could then forecast that, yes, I will more likely than not be able to navigate successfully the EB5 waters and get an approval. And obviously with the immigration lawyer, you need to then ensure that the funds that you will be using and investing in the EB5, you have the required evidence, the necessary evidence, and if there's issues or questions, you could respond to it.
Well said. And for us, all the prior planning is a huge part of what we do as well. Because like I said, like the regional center and the attorney go hand in hand in terms of making sure that this is successful outreach. And we want to get you your full immigration and your repayment of funds, but this doesn't, just pop together in the microwave. There's a lot of planning that goes on our side of it, as well as the individual clients that goes into it. I mean, from a regional center side, you want to make sure that when you're a client and you start talking to them, that you're talking to a group that has experience, that has done things before. Obviously, you want to have people that have successfully done this before as well. But EB5 is a very intricate undertaking, and there's a lot of different moving parts that go along with it. And it's a landscape that's continuously changing. So, there is a lot of benefit in talking to people that have gone through multiple different iterations of it, so that they can provide you with the guidance that you need to make sure that you're continuously moving towards a successful outcome. Taking just some of the very bare bones. I mean, when you're talking to regional center, you want to make sure that they have a fully functioning and compliant regional center that they are sponsoring their project within. I think that goes without saying. But then once you get into that, you want to make sure, is this project going to meet my immigration and investment goals, right? From an immigration side of it, you want to say certain things as just high level as, has the project, has the regional center is in compliance, has the project itself filed the forms that are necessary, the 956F form, to be able to allow for investors to file their project petition along with it. Has the regional center made sure that they have structure itself within a defined targeted employment area, so that your investment level will be appropriate for the project that you're sponsoring. Targeted employment area, you're making an $800,000 investment. Most every project will be within a targeted employment area, but you want to make sure that it's meeting those qualifications. You want to make sure that all of the different aspects down the line are being taken care of. Like, does the project have sufficient job creation for me to ultimately get my conditions removed from my green card? Is there sufficient nexus of that job creation to my spending, right? That you're not trying to take credit for jobs that might have occurred well before the involvement in the project, right? Making sure that all those things are happening. And you want to obviously be dealing with a regional center that has handled this before. I mean, for us, we want to make sure that we're taking the most conservative pathway in all of these different aspects of the investment. We're only going to start counting job creation once we have a commitment letter and we have committed ourselves to the project. We want to make sure that from a repayment of capital standpoint, that we are taking the most conservative pathways to achieving this. We structure our projects as loans. This gives our investors a little bit more comfort in that they have a more defined time frame of when their funds will be at risk. This means that they have a higher priority in the capital stack. It means that we have the ability to secure more collateral for it. But these are all things that tie in together for it, because you want to make sure that your investment has enough time frame that is defined from your return of capital standpoint, but you want to make sure that it has enough time frame to make sure that your funds are suitably at risk, because there is a sustainment aspect of your investment. And we are always going to make sure that we have loan terms, that we have terms of our projects that are going to comply with the USCIS aspects of it, and to give our investors the best chance of getting their funds repaid back to them. Because these things are all intertwined, just like the immigration attorney and the regional center are intertwined, and they're all equally important in making sure that you come to these outcomes. And generally speaking, I think it's important to make sure that that when you're coming in and you're doing these plannings, that you have the right expectation for what the outcomes will be, which is primarily to get those main immigration goals and investment returns completed. So,
and let me just add this, because just to add a little bit of that, all these different points that you touched about, it's a loan, the use of funds, job creation. We have to understand how the system works, in the sense that it's a paper filing. Yes, there's you attach it to a 956 and et cetera, but it's the paperwork, and having the right paperwork to prove all these different points is critical. And again, I've had the privilege of working with Can-Am, whereby you have the experience and the know-how of what type of evidence is required for these different requirements that have to be proven through the EB-5. One of the things that sometimes is, for some new projects entering into the EB-5 system, and not understanding that this is a regulated industry, and not understanding the regulatory aspects of that petition, and not having that proper paperwork, that proper data to back up, could get you into trouble later, could get you into inefficiencies later. So again, all these things are very critical, because, for example, again, in having the privilege of working with Can-Am, a lot of times from the project side, all of these things are furnished by the regional center, where the immigration lawyer is double checking that everything is okay, et cetera. But without having that template, for lack of a better word, without having that type of evidence, obviously it could make it difficult. And if you have a new practitioner that does not have the experience of looking at better petitions, and you are working with a project or regional center that does not have that experience either, you could get into troubles, because there's deficiencies in the data. There's evidence that is not there as far as the use of funds or something else, or how it's a timely job creation. So it's really critical to ensure that at the time of filing, the petition obviously has a greater chance of success, because all the different requirements for the EB-5 are satisfied. Where did I get the money? How are they going to use the money? How are jobs going to be created? The economic plan, the use of funds, and all these different requirements that are satisfied in the petition, on the data, in the evidence that's there, and obviously to provide it to the client or the ultimate investor, so they know what their petition looks like.
Absolutely. No, well said. And so now when you're talking to a client, so the client has put forth a good faith petition. They're moving forward and they're patiently waiting to try to get their approval to move forward with their benefits. What are some of the causes for delay that maybe one would see during this? And when would now this be potentially a time frame for when litigation would be appropriate or warranted for, say, this first petition that someone would file, the I-5260, the petition for conditional permanent residency?
Correct. And one of the tool in litigation, one of the tools in litigation is if a petition is pending for too long. There's something called a writ of mandamus, which is a lawsuit in federal court to ask the government to please decide my case. Now, when is that appropriate? When a case is generally pending for too long. What is too long? Usually the
That's a good question.
USCIS publishes what's something called processing times. And there's a debate of whether the processing times are accurate or not accurate. And off the top of my head, I don't know what the processing time is right now on an I-526, Pete, but I think it's like, over 3 years. Maybe over 5. I mean, I don't know what the processing times is.
It depends on if you're a pre-RA investor, it depends on if you're a post-RA investor, if you're filing in one of the set-aside categories. Because yeah, we've seen petitions take as long as what you quoted. We've seen petitions with much more rapid adjudications who are post-RA investors who have potentially filed in one of the set-aside categories. So the spectrum is wide, but I think that because that spectrum is wide, sometimes it can give the impression for clients that it's too long and that now is the time that they need to that they want to be acting. And so, and look, investors everyone has their own set of circumstances. But if someone was coming into this and were to say to you, oh, well, writ of mandamus, that's a possibility for someone in my situation. Well, what could the potential outcome for that be? And how long should I potentially wait to move forward with this?
So again, the writ of mandamus is because a petition is pending for too long. What's the petition? The I-526 petition is pending for too long. And you got to look at the processing times. Generally in my firm, we don't, I've heard of other petitioners filing a writ of mandamus after 6 months of a pending petition on I-526. I think that's pushing the envelope a little bit too aggressive.
Okay.
What's the worst that happens in a writ of mandamus? You lose. What does lose meaning? Well, you keep waiting for the decision, but you lose what it cost you to do the writ of mandamus. So losing doesn't mean a whole lot in a writ of mandamus because he's just telling you to wait in line. There was a case in a circuit court in Washington, D.C. where they said, okay, well, a writ of mandamus may be skipping the line, but that's a lot of cases when you are reasonable in the amount of time, and generally just out of, we like to wait for over a year at a minimum. On an I-526, I-29s are a little bit different. And it depends also on the venue, meaning if the person is in the United States with an adjustment of status or they're considered processing. But at some point, you got to have a discussion with your lawyer. At which point is it appropriate to file a writ of mandamus? And is it appropriate for me to file a writ of mandamus? Now, let me explain a few things about the writ of mandamus. What is a writ of mandamus? Like I said, it's a federal court lawsuit to ask the government, please decide my I-526 petition, if we're talking about a writ of mandamus for I-526 petitions. But that's decide my I-526 petition. Doesn't mean approval. Now, a lot of times when you file a writ of mandamus, you need to talk to your lawyer. And if your lawyer represented you in the underlying I-526, and they're going to be representing you in the writ of mandamus, obviously the lawyer knows the strengths and weaknesses in source of funds and the project. Because once you file a writ of mandamus, you could get what is called a request for evidence or a notice of intent to deny. And you file the mandamus, you get a request for evidence or notice of intent to deny. It could be source of funds, it could be project-based, it could be both. Then you need to respond to that. Now, generally speaking, when we file a writ of mandamus, and that's the issue, we work with the government attorney to continue the writ of mandamus, to suspend the case, so you can answer that notice of intent to deny, which is 30 days, or a request for evidence, which is generally like about 12 weeks that you're provided to respond to that, or 87 days. So, once you respond, then you can negotiate with the government to make a decision, a final decision. Once the final decision has been made, approve or grant, that writ of mandamus is done and finished. If it's a grant, everybody's happy. Nothing to do. But if there's a denial, then you may have to exhaust administrative remedies, going to an AO appeal, for example, and then you have further litigation down the road on what is called an APA review, or a review of whether the denial is lawful, is not arbitrary and capricious, is appropriate. But again, the mandamus is an incredible tool to get a decision on long pending cases. A lot of times, like I said, the government just doesn't want to be dealing with them, and Davison tells the government, look, just issue a request for evidence, approve it, or issue a NOI. They do not just simply deny it. I mean, I've never seen a just straight denial. I've seen a notice of intent to deny, request for evidence, you respond to it, and then you get a final decision, you could adjudicate it. There's been some pushback, and again, what I said is some people are too aggressive and they go in, and there's been some pushback by some courts to say that, well, no, you need to wait your time like everybody else. And then you get into something called the track factors as a litigator. There's a multi-factor test that the court can look at, whether it's pending too long, whether hardships and other factors that are determined. And a court could ultimately, if it's not settled with the U.S. attorney, to issue a NOID, request for evidence, or ultimately a decision, then there could be litigation in court. It adds to the cost of the litigation, but there could be litigation in court, and there could even be discovery that you asking the government, where did you come up with these processing times if they're made up? Because they have something called first in, first out, and they have, so you could get into those aspects, and a court could ultimately say, government, decide it. Or no, you got to wait your turn, and your turn, and you're skipping the line. But ultimately, the mandamus is obviously, if you think it's pending too long, consult with your lawyer, consult about the timing, consult about it, analyze the underlying petition on both for source of funds and project base, and determine that, look, this should be approved, and I think we could survive any questions that they have. So you could get your resolution, and you could obviously be on the road, obviously, to get your conditional green card.
John, what's the time frame that that the government has to provide a response to your writ of mandamus in?
Correct. Once you file the lawsuit with the government has 60 days to answer that lawsuit. In that 60 days, the government usually, a U.S. attorney enters into the picture. They could enter on day 1, they could enter on day 59, but they got to answer the lawsuit. Now, this is, in my experience, a lot of times what happens is the government attorney enters even on day 59 and says, look, we're going to issue a request for evidence. Could you delay the mandamus? Sure. And I've sometimes delayed it pending look, I'll give you 3 weeks, give me the RFE or the NOI, or you issued it. So then you work with the United States attorney to continue it. If they issue a NOI, if they issue an RFE, respond to it, continue with the mandamus pending until the ultimate decision. If the ultimate decision is a denial, because now the mandamus works for both I-526 and I-829, because the application to remove conditions. You could also file a mandamus when an I-829 is pending too long. You could do it for both. You could also do a mandamus in some cases for the I-485. What I mean by that, in concurrent filing cases, you have some cases that the I-526 is approved, but the I-485 hasn't been approved. And without the I-485 approval, you don't have a conditional green card yet. So you could mandamus any type of petition. I-526 petition, you could mandamus that. You could mandamus the I-485 petition as well. You could mandamus the I-829 petition to remove conditions. And again, that requires a consultation with your lawyer to determine how long has the petition been pending, and is it approvable? Because I've seen a lot of cases, Peter, where people file writ of mandamus, and the case had clear flaws, where they get a denial, and obviously then that leads to other issues, etc.
Yeah, no, I think it definitely it's a tool, and it's definitely a great tool to have it at your disposal, but it needs to be done strategically. And it's great, and that's great. It's like that this is a writ of mandamus is a possibility for each of your petitions that you're looking at, and that's definitely helpful to know. But doing it the correct way to make sure that you don't put yourself in some unintended consequences is fantastic advice. So for an investor, let's say, so an investor now, they've now received their I-526 petition approval, whether it's through normal course or whether through writ of mandamus. They've either gone through the consulate, gotten their green card that way, or they've had their I-485 approved and gotten their adjustment of status completed. They've started their conditional green card status, which is fantastic. So they've gotten their conditional green card. The only condition being the time frame, right? It's a 2-year conditional green card that they're operating in. 21 months into that, they file for their I-829 petition. So now that they're at the I-829 phase, there's some different things that go along with it. You need to make sure that you have shown the job creation has occurred. And so this goes back to our initial discussion about making sure that you're working with a regional center that has done prior planning and proper planning and has sufficient job creation for you to evidence at that stage. What sorts of complications could someone potentially be, and at what point might litigation be warranted at the I-829 stage?
Let me back up a little bit on the I-526 before I answer that question, Pete, because
Sure.
the IRA set up an administrative. So if you file a mandamus on an I-526 and it gets denied, you have to go through the administrative appeals office first before you get to federal court in challenging that denial of the I-526 on an improper application of the law. So you have to exhaust those administrative remedies. And this is where you got to talk to a lawyer because it affects what happens if I'm in concurrent filing. And it could affect other issues related to that. But the IRA, the law in 2022 created that additional hurdle. Before the IRA, as soon as the I-526 was denied, I could go on an APA action saying the denial was wrong, arbitrary, capricious, illegal, improper, etc. And I could challenge that. Now I got to go through the AAO before I have that federal court review. And I could win it at the AAO. I won some cases at the AAO, but obviously you just have that final. But I just wanted to clarify because that exists in the I-526. You have to exhaust administrative remedies through an administrative appeal before the administrative appeals office. At the I-829, when you're removing the conditions, as soon as you file it, your green card's extended automatically. So you continue to be a conditional green card holder throughout that period that they're deciding your I-9. Even if
And
the
how
I-9
long is that extension for? Just
right now they're giving you a receipt that's good for about, I think it's 48 months. So as soon as you file the I-9 with your expired green card and the receipt that you timely filed your I-9 3 months prior to the second year anniversary of the 21st 21-month mark, you get the receipt and it automatically extends it. And I believe right now the extension is up for 48 months. If it was pending beyond that period of time, you could still add it. You could get stamps on your passport that shows that you're a resident and you have all the rights and privileges: live, travel, work, study, whatever.
And you have consistent residency. There isn't a gap in your status while this other petition is.
And you're on your way also to have the necessary period of time to qualify for citizenship once the conditions are removed. Now, if the I-9 is pending too long, you could do a mandamus. And again, you could get an RFE, request for evidence, notice of intent to deny, respond. If the I-9 is approved, you got a permanent green card and you can get citizenship. You could apply for citizenship prior to the approval of the I-9, but generally don't grant it. You have to get the I-9 granted before that or remove the conditions to get citizenship, but you could apply before that. But if the I-9 denied, what happens? You're still a resident and you can renew the I-9 further litigation in front of an immigration court. It's not the end of the road. You have further review, but the review in an I-9 denial generally happens now in a removal proceeding in front of the court, in front of an immigration court, not in federal court. When I started practicing, Peter, we would have an I-9 denial and go to court. One of the only precedent decision at the circuit court level my firm obtained, called Chang, about 20 years ago. And now what's happening, if you challenge an I-829 denial in federal court, they'll put you in an immigration court process and say you got to review it there. The advantage of being in a removal proceeding, and I'll explain a little bit different, is in a removal proceeding in front of the immigration judge, the record's open. I could submit more evidence from the regional center that my money was used, the jobs were created, and all that. It's not frozen. When you have a federal court review, I cannot add evidence. That's why that initial application becomes very critical. That if
Mhm.
it has everything, I could win that federal court action. If they would deny it wrongly. At the I-29, because the length of time and things happen, and in the pandemic, there were, there were some projects, not with Can-Am, but there were, that they got into delays or so, but you were able to successfully navigate, and we were able to successfully navigate in front of the immigration judge that, look, the money was used, we created the jobs, etc. So again, you could do a mandamus for the long delay on the I-29. Worst case scenario, you'll be able to continue with your green card and have an opportunity to still win the I-29 in front of an immigration judge.
Which is huge. And again, I think it's where the strategy comes in and good advice comes in, because sometimes plowing ahead too quickly on these things could get you your decision potentially, but it doesn't mean it's going to be the decision that you're looking for. So making sure that you have the ability to continue and to have a successful outcome is hugely important.
Absolutely. I mean, and this is again goes back into working with people, a regional center and a project that knows how to do it.
Yeah.
Nothing like experience, right?
Absolutely. Absolutely. John, you're so, I mean, you're at the forefront of all of these different decisions. Like what sorts of things, come to you that are, I guess, that are interesting or that are just pertinent in the litigation world that, might be helpful for an investor, might be helpful for someone else who's coming in and trying to see what sorts of things could be avoided in the EB-5 world, or what sorts of things could be looked further into and might be warranted for maybe someone like your services.
Let me just say this. I think it's always been important to partner with a regional center on a project that increases your chance of success. But one of the things that the IRA created is concurrent filing. So you could file your I-526 with your I-485. Now, concurrent filing is an amazing tool because, obviously you don't have to be waiting outside. You get employment authorization, you get a travel document, you could do certain things in the United States that kind of look like a green card, right? You could work, travel, study, do all that while you're waiting for it. So we've seen a little bit less pressure to, I want my decision right away. But at the same time, it creates one challenge as an immigration practitioner. If the I-526 is not approved, it creates problems for the investor. It creates problems for the investor remaining in the United States. It creates problems for the investor doing other things. And that's where part of your due diligence is very critical, because you want to partner with a regional center on a project, and you want to be in a project where your opportunities, your chances, your probability of succeeding at the I-526 are greater, because the consequences of having an I-526 denial may mean that you have to leave the United States right away. Because once the I-526 is denied, they could deny the I-485. And once the I-485 is denied, there could be other negative consequences. I'm not trying to scare people, but one of those consequences, you could be put in a removal process. Unlike the removal process in immigration court at the I-29, where you continue to be a green card holder with rights and privileges, if you get put in a removal proceeding because you got your I-485 denied, the immigration judge is not going to be able to look at the I-526. So the immigration judge in that case may simply say you need to leave. So, there's very seriously real consequences that, number one, you got to talk to your immigration attorney, but number two, doing that due diligence on your I-526 becomes extremely super critical. And I know a lot of investors say, look, but the return of investment or this and that. And, what I, as a practitioner, what I say is two things. Yes, return of investment critical, but capital preservation is even more critical, because you could have a supposedly high return of investment and, it just it goes bankrupt, goes south.
Yeah.
That just happens. That's just that. But so and the second thing is obviously not only the chance of getting my green card, but the chance of, because if you have an I-485 pending, I got my kids in school, and you got that I-5 to 69. Now everybody has to leave. My kid is in school in the middle of the school year. Oh my God. And in today's environment in the United States, I mean, there's a lot of challenges, there's a lot of opportunities. So again, protecting your status becomes more critical than ever, and having that the best possible I-526 pending becomes more critical than ever, because that increases your probabilities of getting that I-526 approved and not, navigating these waters without any problems and no storms. I'm from Florida. You don't want to be in a hurricane. You don't.
Don't want to be. You don't want to be if you don't have to. Listen to the warnings, right? And avoid the issues before they come. Well, thank you, John. I mean, this is all just such fantastic information. I mean, I think just in summary and conclusion here, really the best use of litigation is to not have to litigate at all, right? And it's to make sure that you're talking to the right people and you're making all of the right planning decisions before moving forward with it. And then litigation can be a very important tool when you have done all these things correctly, because even if you do have to end up litigating, having done these things correctly beforehand is going to make your litigation that much better as well. And there are some more outward use of litigation that you can use, writs of mandamus, all these sorts of activities to be able to potentially prompt a decision, but they want to be used strategically. And and to make sure that you're getting good advice, and if adverse things are happening with yours, that you do have someone like yourself that is able to then help you to navigate through some of those next steps in different appeals courts and whatnot as well.
Yeah, let me say just two things in conclusion. I mean, there's a saying that says, prepare for the worst, hope for the best. I think an EB5 is a little bit different. Is prepare for the best outcome and be ready if there's issues, with litigation, etc. But the other thing also I would add is this: that you have a lot of people that invested in failed projects, and you have a subsection in the INA that created, it's called subsection M, where people in some regional centers that got into trouble, etc., could reinvest money and put it in a new regional center and again protect their EB5 interest. It becomes critical for those type of people to then partner with a regional center in a project that is appropriate enough, in order that if you could do that new investment to try to keep your priority date, etc. So not only you have now, Peter, people that want to make that new investment, but you have people now that invested in the wrong project. And one of the things that I hear the most from those people when I say, look, and obviously I've had a great relationship with Can-Am, and you're at the top of my list as far as, on all these years, as far as, look, this is a regional center that I can trust. I know the people, I know what they do, I know the projects that they've done, I know that the reputation and the know-how. And when I get an investor that's been defrauded, or what is the problem, I just lost $500,000, whatever, I don't have the appetite. And this is the frank discussion where, like, well, look, do you really want to go back to your home country? You're going to get your I-290 denial, but there's this end protection. Maybe make it in a new investment. And obviously that's an option, and that's a class of investor that we generally did not have before 2022, where you have old investors that still need to make a new EB5 in order to get those subsection M protections. And again, doing your due diligence, whether you're a new investor or you are someone that needs to protect their EB5, partnering with the right regional center, the right attorney, and understanding how litigation can help you. Because I'm having to make some of these arguments right now on I-290 denials in immigration court. So, the landscape is changing. There's a lot of challenges, but a lot of opportunities. And, obviously you just need to be with the right professionals in order to protect your interests and your family's interests.
Well, I can't think of a much better way to finish off for everyone than that. But John, any final thoughts or any?
No, I mean, EB5 is an amazing tool that gives you a lot of flexibility concurrent filing, it gives you the flexibility of work, study, do anything you want, and eventually get a green card. So, you know, it's a tool, and litigation is a tool, and understanding how, you know, to increase your chances if litigation requires, but to then again prepare for the best, meaning increase your probabilities of chances of success so you could get, you know, what you want from you and your family as an immigrant.
Great. John, thank you so much for joining us. Thank you for the work that you do for your clients, for the industry as a whole. It's fantastic. You, KKTP, are doing fantastic work, and thank you for joining us. I think this has been tremendously helpful for our clients and people who are interested in the EB-5 program.
Peter, thank you again for the invitation. Glad to work with you guys, and you know, we'll keep going and achieving great things.
Thank you, John.
Thank you.